Please remember, none of this should be taken as financial advice or legal advice. I have a bias towards the XX network.
Hi, everyone. Today we have Jeremy Hogan, none other than Jeremy Hogan. How are you tonight, Jeremy?
I am doing excellent. I'm in Vegas and I'm not drunk. So there we are.
Well, I appreciate you coming on to my show and discussing everything that has happened. I see there's like a bunch of Bitcoin maxis that are telling me that this case is definitely going to get appealed and it's definitely going to hinder Ripple's business. I just wanted your comments on that.
Sure. So the first thing to keep in mind is that as of right now, the law of the land is what's in that order. So XRP is not a security. Ripple institutional sales were sales of securities, but all the other sales were not sales of securities. And until an appellate court comes out and says otherwise, that is what it is. That doesn't change just because someone files a notice of an appeal or even an appeal. The law is what Judge Torres said it is, and that doesn't change until an appellate court, which is above her, says otherwise. So, I've been hearing the Bitcoin maxi saying that it's going to be appealed, and it might not. I could talk about that in a little more detail, but until that happens, nothing changes until that happens.
But does an appellate court really want to undermine what Judge Torres has said? Does that what they do, or do they bring in new facts, new arguments, and it's kind of like the appellate courts go over new evidence rather than undermine what the last judge said, right? That's not really how it works. Is that correct?
Yeah, that's basically correct. And you're touching on something which I think is important, is that the way that the judge wrote her opinion, if she had made a decision based upon the blue sky test, upon post-loss obligations test that Ripple and I were pushing for, what would have happened is she would have been ruling on a pure area of law. That's more likely to be overturned than a ruling on facts, because appellate courts defer to judges on the facts, but they overturn them on the law. And so what Judge Torres did, I think, was very smart. She made her opinion based on the Howey test. And what she said was, well, these programmatic sales, the purchasers did not know who they were buying from, and even Ripple didn't know who was buying XRP, and therefore there was no expectation of profits. And so she couched her opinion in terms of the facts, and that's more likely to stick. That's less likely to be overturned on appeal, because you're right, appellate judges don't like to dig into the facts of a case and say that the trier of fact, which in this case is the judge, was incorrect.
All right. So they're not trying to undermine her. They're just the new stuff that comes in. And I mean, does this affect Ripple's business at all? If they're global, right, they can sell the investment contract if they are labeled investment contracts anywhere, right? Does the SEC oversee the entire world where they sell investment contracts because they live in California? Is that how that works, or is there are they allowed to sell to Japanese investors or however?
So the law is that there has to be a nexus to a U.S. purchaser or someone in the U.S. So as long as there's no nexus, and nexus can get complicated what it is, but basically, for example, if Ripple was to sell to a Japanese bank, the SEC has no jurisdiction over that sale. So there has to be some connection, I guess is a better word, to a Darren or to a Jeremy or to a Bank of America, and not just a foreign sale. So, and I think Mr. Schwartz came out and said something to the effect that, most of their ODL sales are not to U.S. based purchasers. Therefore, it's not really going to affect their business moving forward.
Right, and the programmatic sales, that those are sales just into the market, which that's kind of what ODL does, right? They give the XRP to a market maker that distributes it into the market, so that doesn't get affected either. So really,
correct. I'm sorry to interrupt. I mean, the judge kind of hung her hat on that whole, the buyer didn't know who they were buying from and the seller didn't know who they were selling to. So it's that relationship is what the judge focused on. And so even in an ODL purchase, if it's Bank of America purchasing XRP in order to move some money from America to Japan, for example, even though they only hold the XRP for a short period of time in the ODL process, is my understanding, that could still be considered the sale of a security. I think that's the only weakness in the, in the judge's order. If you want to find something that's problematic, that's a problem for Ripple, or something that Ripple doesn't like, is it's hard to say when. I think the weakness in the reasoning is with the ODL cells. I mean, my understanding is that the banks are buying XRP just to use it for a very short period of time. And when you're only holding XRP for a minute in order to transfer value to another country, it's hard to make an argument that you're actually looking to Ripple to increase the value of XRP because you're only holding it for a minute. So, what's the point of, you're not really buying that as an investment. You're buying that just specifically to use it for that one purpose, for that 1 minute. And if that's the case, that's the only thing I think Ripple will have a problem with this order, because in theory, based upon what the order says, that sale, even though they only buy it and only use it for a minute, would be the sale of a security, because if the bank knew who they were purchasing from. Does that make sense?
Yeah, that does make sense. But I mean, the way I interpret it was like, if the banks made the investment in XRP to hold for the long term, right? That would definitely be an investment contract. Yeah. And for that though, I mean, like, is there a special licenses banks need for an investment contract? Does that exist? If I wanted to buy an investment contract from somebody, the SEC regulates that, but is there any licenses or anything that you need to even buy an investment contract?
Not the purchase. It's only the sale really that the SEC gets involved in. So, there are other ways possibly that Ripple could sell to institutional investors. So the order says that institutional sales were sales of a security, but there's other ways you could sell a security that's legal other than registering XRP as a security. There's Reg D sales, there's sales to certain investors. The only problem is that those sales come with some kind of anchors that attach to the security. So there are certain ways that Ripple could sell to institutional investors in the US and do it legally. But there's some limitations on how you could do that and what you could do with the security after. So for example, there's limitations on the amount that you could sell. I think it's $10 million a year, which of course doesn't really help Ripple. And then if you sell it as a security to someone, they have to hold it for 6 months. And that might not be something that a Bank of America would want to do. So there are ways that you could sell that Ripple could sell XRP as a security to a bank and do it legally. It's just probably not something that they're going to want to do.
Okay. And I mean, like you said, 10 million wouldn't really do anything for what they're trying to do. And so pretty much the SEC has cut off institutional investors in the United States, but globally, Ripple still has every other VC globally, which a lot of these VCs have global arms anyway. So they just refer them to BitHump USA versus, the Bitcoin, whatever fund, Bitcoin Global versus Bitcoin USA. So all right. I guess, kind of weird.
I mean, it's a weird ruling, but that's the way the law, that's how the judge interpreted the law. And so some of the effects, as a judge, she doesn't understand Ripple's business 100%. Neither do I. So, you're saying here's the law, and then how it comes out in the context of Ripple's business could come out in kind of a weird way. And I think that's what we're seeing, especially in the ODL cells where the period that they hold the XRP could be such a short period of time. It doesn't really make any sense, but it is what it is.
Yeah. And the other thing is, Judge Torres, like there's an excerpt from this that says XRP is not in itself a security, right? So will that protect retail even with the appellate courts or Supreme Court? Like, just her writing that, will that help protect the retail holder from future litigation if there is future litigation?
Yeah, I believe it will, because, well, let's talk about that a little more detail, because that's where things I thought got really interesting in the order. So first off, the judge basically said in a footnote that she cannot rule on whether XRP in the secondary market is or is not a security. She explicitly says, I cannot rule on this because it was not brought forth in front of me properly, right? So then when I read that, I was like, okay, well, this is not going to go well. This is horrible. We're not going to get any clarity. But then she continues on, and as she makes her order, she basically says, well, actually, she explicitly says, XRP is not a security in the secondary market, right? And so she gives us what we really want without making it a part of her official order, because it really wasn't in front of her. And I agree with her on that. So what she does is she quotes language from other cases, but couches it in terms of XRP. So I think the big part where she says basically XRP is not a security in the secondary market, she just quotes from I think Marine Bank case or something like that. So it protects XRP holders from any argument in the context of XRP that XRP is not a security. Now, it's just a trial level order. So non-XRP digital assets are not covered by this order. So this order only applies to XRP. It doesn't apply to anything else. Now, it's persuasive authority in those other cases, but it's not binding on anyone. And there's cases that have either not addressed it or kind of said something otherwise. An interesting thing is that the SEC attorneys, or the SEC's position on this, is that once something is a security, it's always a security. And I even talked to SEC lawyers who basically said that. And when I said otherwise, they kind of rolled their eyes and said, "Oh, you don't know what you're talking about." And that was about a year ago. So I'm glad I got the final revenge on that one. But the judge is basically saying that just because XRP was sold as a security, as an investment contract, that doesn't mean it's forever in existence now there's certain things that are forever securities. For example, a share of stock. If you own a share of Apple stock and I buy it from you and you hand me the certificate, that's a share of a company no matter what you do with it. That's always a security, right? So it maintains that designation throughout its lifetime. But what the judge says here is that you have to analyze every sale in and of itself as far as XRP, the digital asset. And that's as far as this ruling goes. So it's very clear as to XRP. It's not so clear as to any other digital asset.
Okay. Well, it kind of gets into some of my other questions about this case kind of setting precedent for other cases, particularly the Coinbase lawsuit, right? That's kind of a bigger U.S. case. And does this case set any precedent for other crypto cases outside of just, XRP is not a security part?
Well, it's a very influential case, even though it's not binding because it's just a trial level judge, but it's influential because it's the first case that's really addressed that in the digital asset space. Like, for example, in the library case, the judge just kind of punted on it and didn't really talk about it, said, I can't talk about this because it's not in front of me. Judge Torres went out of her way to say, look, I'm going to help out the XRP holders here and just say, this is not a security in the secondary market. And so it's going to help Coinbase a lot because it's going to be very influential, even though it's not binding, meaning they could follow it or not follow it, but they should kind of take a really hard look at her opinion and take it into account when they're looking at all of the coins that were alleged to be securities on the Coinbase platform.
Okay. And I don't know if you saw the video clip of like Gary Gensler at like this lunch meeting. And he was saying that he's going to look in and assess everything. He really thinks that the retail investor needs to get protected and all this stuff. Is there anything that you read between the lines with his quotes when you heard his clip?
Well, I think there might be a little bit of a game of chicken going on here, because here's the situation you find yourself in these when you're talking about an appeal. So you have a certain limited amount of time to file a notice of appeal. At least right now it would be an interlocutory appeal. If the SEC files for an appeal, Ripple's going to want to file for an appeal because you want to go in and have, like, Ripple, of course, doesn't like the institutional sales part of the order, which they lost. So if the SEC appeals, Ripple's going to want to appeal. And so, you're kind of playing chicken with each other right up to the last moment. I bet that Ripple has an appeal ready to go just in case the SEC files theirs. But I couldn't really read too much into what Gensler said at that luncheon. Of course, they're looking at an appeal. You always think of an appeal when you lose. My personal opinion is that I don't think the SEC is going to appeal because I think they have more to lose than they have to gain.
Yeah, and I mean, like every case, right? They were trying to do this really broad net, trying to capture everybody, and they really should have settled before the summary judgment, because then there would have been more ambiguity in the market, and they chose not to, and they pushed this forward even more forward, and now other cases have this to leverage against them if they try to sue them in the future. So really odd strategy. Like, there doesn't seem to be a strategy. It just seems to be just making a big scene until you get called out for it.
Well, understand, Darren, that the SEC has won every case they've brought out there up to this point. And I believe that they fully expected to win this case. I think this was a bit of a surprise to them. It wasn't a surprise to me, but I think the SEC wasn't really ready for this to happen. So I think they're stepping back and taking a look at what they could do. I mean, the problem with an appeal, of course, is how long it takes. I mean, we're talking, a year and a half, 2 years. Is Chair Gensler even going to still be, the head of the SEC at the time? I mean, a lot can happen in 2 years. It just drags this whole process out. I think the problem with the settlement before now is, I think that my guess is that the SEC was going to Ripple and say, we'll settle with you, but you have to register all of your XRP as a security moving forward. And that destroys Ripple's business model. So I don't think that it was really in the works. Now that we have a non-security designation, that might change. The chance of a settlement in this case just went up tenfold, from Wednesday until now. So we'll see what happens. There could still be a settlement in the works, because maybe the SEC is going to just move on from this whole, we want you to, register XRP as a security issue that I think they've had. But, we'll see how it plays out. I would bet that there's no appeals coming at all, but I'm in the minority. Most attorneys think that there's going to be an appeal. Most attorneys think that the SEC is going to appeal.
Hey guys, before we continue the show, I just want to point out that this Friday at 4 p.m. Eastern Standard Time, we're going to have Alex Shazik, a lawyer from the Digital Chamber of Commerce, who's also ex-OKX, and he has his own show called The Dollar Show, and Michael Garber from Swirlds Lab and Forum. He is one of the guys at Hedera. We have Ben Wagner, which is the chief engineer in XX for the XX network, and we have Eleanor Tourette from Fox Business. She's a journalist for Fox Business. So remember that this space is open for everyone to join. It's at 4 p.m. Eastern Standard Time. So be sure to put it on your calendar. I'll put the link in the description below. And also just remember that proxy is free to use. This is a way to conceal your IP address from any wallet transaction that you have on MetaMask or any wallet that allows you to customize the RPC. Once you connect to proxy, you connect to CMIX, and all your information is erased from the blockchain completely.
Yeah, I'm hearing that too from mostly like the Bitcoin guys, and they pretend like they don't have a bias while they're telling this to you, but they the way they word it, they're like trying to treat you like an idiot if you're not a lawyer, and that's been my conversations with the Bitcoin lawyers so far. It's like, they're definitely going to appeal, they're definitely going to do this, but I mean, they look foolish, in my opinion. Like, Gensler is like a career politician, right? Like, he wants to be treasurer of the U.S. That's his end goal. So the more he pushes this, the stupider and stupider he looks. And I mean, that has to have some type of influence on him. And like you brought up, they didn't think they were going to win, but Ripple hired the SEC to fight the SEC. They had Barry Joe White like leading the case, and they spent a ton of money to do this. So I don't understand like why they would think this would be an easy fight or anything. But
well, I'm not a Gary Gensler defender, but he didn't bring this loss. He wasn't even a member of the SEC at the time this lawsuit was filed. So he was kind of left dealing with this. I think the SEC, to their credit, has gotten a lot smarter in the last 2 years since he's been the chair of the SEC. I mean, their strategy pre-Chair Gensler was pretty just whack-a-mole. I mean, they didn't seem to have a strategy to digital assets. They were just kind of, filing a lawsuit here, filing a lawsuit there. I think this last 2 years, you've seen a much better strategy out of them. I think they at least have a strategy. I think this case wasn't something they probably would have brought with Gensler in office, to be honest, because this is not the fight you want to. I used to work for an insurance company. And it wasn't me. I was a low-level attorney for this insurance company, but they had their older attorneys would have, litigation strategies. How are we going to, get favorable case law for insurance companies, favorable legislation for insurance companies? They were always thinking about that. They always had a strategy for how they were going to play it, and they're very good at it. Progressive insurance is very good at doing that, and SEC didn't even really seem to have a strategy until like the last 2 years. So, at least they have a strategy now. I think this case would not have been part of that strategy if it was their choice, but they were kind of left with it when they took over. And this is not the fight that you wanted if you were the SEC. I would never have taken this on. You want to attack the smaller projects, the weaker projects. You're a lion, and you want to go after the young deer. You don't want to go after that big stag that has some horns. And that's what they did. And I think that was a big mistake.
Right. And I mean, like you were saying, that the going after the smaller projects. So they did go after like BitConnect. They went after Telegram, EOS. So they went after the ICOs. They went after the outright frauds. And then in the last day, they went after Ripple, right? The last day, Jay Clayton does. That whole thing, right? Like that's where this whole ETHgate type of situation really sparked my interest, because that's when Alibaba was like raising money for their payments platform that they were supposed to do on Ethereum. This is where like Bill Hinman's calling Vitalik to get information for his speech that he's going to give as market guidance. But no, it's not market guidance, but we're gonna give it as market guidance. Do you think anything comes from to Ethereum since they had the ICO, and this case is different than Ethereum, or they're just going to back off of the strong deer from now on and just go after the little ones and pick off the weak and sick?
I think the only way they would go after the Ethereum Foundation or anyone related to it is if there was political pressure for them to do so. And I don't see that political pressure having built over the last 6 months, even with the Hinman emails being released. If I was betting, I would bet that never happens. Their new strategy, which I think is a better strategy, is instead of going after individual projects, what they're doing is they're going after the exchanges and the on and off ramps to the exchanges, which is the only way not to play whack-a-mole. Because even though Ethereum is a humongous project, it's still just one project. And so what they're doing instead is they're going after the exchanges and alleging 16 coins on an exchange are sales of illegal securities. The reason that's smart is that you're putting then the onus, the burden is on the exchange to defend each of those 16 coins and say each of those 16 coins are not securities, even though they don't have all the information to defend them. So I think that's a much smarter strategy that the SEC's playing right now. And because of that, I think Ethereum is probably going to be off the hook.
Okay. All right. And the way to change all of this is with Congress stepping in and actually making clear rules instead of them just going after each exchange. I mean, so the SEC makes their money through their lawsuits, right? They're like partially funded by the government, but they also make money through lawsuits. Is that correct?
So it's not my specialty, but my understanding is that the SEC is funded from the general fund, from the general treasury, and the fines and the money that they collect from these lawsuits goes back to the general treasury budget. So, of course, it looks better though if they're self-funding. So I think from a political standpoint, that's helpful. But I don't think they're literally trying to get money in order to keep their funding going.
Okay. I mean, like I kept seeing all of the congressional members that were anti-SEC. And then I saw some bill that got passed that was like 200, it was an obscene amount of money that they passed to give to the SEC. So I was trying to figure out like which ones voted for that bill to actually happen, but they ended up giving them like billions of dollars at one point to fight everything.
It's a big agency. I mean, they do a lot. They, the crypto stuff is just one little aspect of what the SEC does. There's a lot of other things they do. They have a lot of lawyers. They have a lot of staff. It's a really big agency. It's an important agency, which, makes me kind of feel a little sad about how they've been approaching the digital asset space. I mean, they really, it's such a big, important agency, and for them to be so hostile to this space is really, to me, kind of a sad thing, because with all the talk about being technology neutral, they really hate the crypto space, and their attorneys dislike it as well. They all think it's just a big Ponzi scheme that they need to protect people from and take it down. And to me, that's unfortunate.
Well, I mean, there certainly are those cases, right? But we haven't seen much come out of those cases. Even like Sam Bankman-Fried was meeting with Gensler, right? Like this guy that's in charge of the Ponzi scheme, shaking hands with Gensler. They don't go after those guys. They're going after the guys that are actually trying to do something productive and trying to, add something to the economy versus take it away.
Completely agree. And, that's my, my big criticism of the SEC is why focus on these failure to register cases when you do have a lot of fraud and you do have a lot of Ponzi type stuff going on in the digital space. You do have a lot of problems with the exchanges. It's there for everyone seeing. Why not attack, the fraud? I don't think many people in the digital asset space would be unhappy to see people that are committing outright fraud have lawsuits brought against them and to have that stopped. I think what people don't like to see is a project left out there doing its thing for 10 years. And then out of the blue, you say, oh, you're selling illegal securities for the last 10 years. We're going to sue you. And then spend all of that time, effort, and money, and our money on that litigation, which at the end of the day doesn't really protect anyone.
Right. And like, that's the point that I brought up to Garlinghouse. It's like, I work in crypto. I'm paying taxes to a government that's trying to destroy the industry that I'm working in to pay them taxes. It's a vicious circle. So, disgorgement is the SEC able to just kind of put a cap on the escrow, or the Ripple can't sell anymore? 718 million, I believe, is one of the figures. Do you think they're likely to get 718 million, or is it possible they close the cap on the escrow at all?
So I do not believe that the escrow can be touched like that. There's a possible mechanism for it, but what's going to happen here is the judge is going to, probably come up with a number. I don't know if it's going to be the full 728 million or whatever that the SEC alleged, or some lesser amount, but that's going to be what's going to be happening in the next couple of months. Is there'll be fights over what the actual amount is, and there'll be maybe a hearing on that before the trial. But I don't think there's no mechanism right now for the judge to say all of the escrow you can't do anything with the XRP. Really, the judge right now is focusing on money. This is a money issue, and most civil cases are a money issue. Like I tell clients, I can't really get you justice. I had a client the other day who wanted me to get an apology for them from the other driver, and I said, look, there's no mechanism for me to force the other person to apologize to you. It's just not the way the courts work. Courts work with money. It's all comes back to money, unfortunately. And I'd love to get your apology for you, but instead, all I could get you is, $100,000 or whatever. And that's where the Ripple case is at. This is going to be about money. And as long as Ripple has the money to make the payment, I don't think the XRP could be touched. There's just not the way the courts work.
Sorry. I found it really funny. She wanted an apology.
I'm not kidding you. She goes, I don't care about the money, Jeremy. I want that lady to say, I was wrong. I'm sorry.
I want her to admit she was being a jerk.
Yes. Yeah. I was like, I appreciate clients like that, because, they're the best. They really want just someone to say you're right and the other person's wrong. But that's just not the way the courts are set up. And I think the same thing that's going on here is right now it's all about money and possibly an injunction from future violations. But the way the injunction would work is the judge would issue the injunction and say, you're not allowed to break the law anymore, which I always thought was kind of silly because of course you're not allowed to break the law, right? So, but she would issue an injunction saying you're not allowed to violate this order, which would be the institutional sales part of it. If the SEC thought that they were violating the order, then what the SEC would do they would turn around and file for, I'm sorry, I'm forgetting the word. But anyway, they would turn around and file something with the court saying, they're violating the order. We want you to sanction them, make them stop. And then there would be more court hearings that come from that. But that still is not a way to, cap the escrow or take the XRP out of the escrow or anything like that.
Okay. So there's really nothing they can do. And then since this is global, right? Like every roadblock they put up, there's some way to bypass it anyway. So it just cuts off American investors, really, VC investors, not retail. And I mean, from a retail perspective, like the only thing that would really be discouraging, right, is if this got appealed, got taken to higher and higher levels, and we just didn't have clarity for years and years to come. But well, I mean, Congress is getting very vocal. I've been studying crypto for a very long time, and there's a time that these words never even came out of congressional members' mouths. It didn't come out of president candidates' mouths, and now this is like the hot topic. And I guess there's a big amount of voters that are going to vote for people. So it definitely seems to me like at one point something's going to break where the U.S. gets some type of regulation, especially if the rest of the world actually has regulations. I can't see why the U.S. would continue to stall their feet with that. When I talked to Craig DeWitt, he said that there must be some type of government think tank that's saying this has to be bad for the dollar or something like that. But I don't know. I guess we'll have to take it from here. But
well, there was a really interesting Twitter thread. I think it was on today from I think it was Mr. Hammond, and he points out that this decision has really made it more likely that we'll see some legislation come across because up to this point the Democrats have been kind of mirroring this whole we don't need legislation, the law is clear kind of trope that Chair Gensler has been throwing out there. But I think with this decision, especially because it came so far out of left field, like how the order was done and what it says, it makes it super clear that actually we do need legislation because nothing is clear about the digital test and Howey. I mean, the Howey test is clear, right? There's this 3 prongs. This is like everything. This is not complicated. You learn this in law school right out of the box. There's always 3 prongs, 4 prongs for a test. So there's no problem with the Howey test. The problem is in applying the Howey test to digital assets. That's where it gets super confusing and problematic. And that's why there's no clarity. The Howey test itself is clear. I agree with that. But applying it to a decentralized digital asset is 1000% not clear. And that's kind of why we need the legislation. And I think this case kind of highlights it. And it also kind of helps that Judge Torres was a Obama appointee. So she's kind of, a Democrat, even though she's a judge. So it's not like the Democrats could say, oh, she was a Trump appointee, so of course she's going to rule this way. So kind of one of their own has basically told them there's nothing clear in this space. And so I think that makes it a lot more likely that we might see some legislation come out next year as far as digital assets.
So is there anything that you want to add that I didn't get a chance to talk about?
I don't, the only other thing that's been running around in my mind that's kind of interesting is, there's 2 parts of this case that are problematic for the SEC where you're thinking of an appeal, because everyone's talking about appeals for some reason right now. But the first part is the programmatic sales. The SEC doesn't like that because it means that the buyer must know who they're buying from in order for there to be the sale of a security or of a digital asset. That's a problem. That could be appealed because that's part of order. But the other part of the order that the SEC is not going to be happy about is the part that says that XRP in the secondary market is not a security. The part that says that the digital asset itself is not a security, or XRP itself is not a security. Of course, the SEC doesn't like that part because that means that the sales on the exchange are not a security unless they're also investment contracts, which of course they aren't because the exchanges are selling them. So those are the 2 things that can be appealed. The interesting thing about this order is that she never really officially ruled on the XRP itself is not a security part of the order. she said it what's called dicta, which means, there are only a couple things that were really in front of her to rule on. The institutional sales, the programmatic sales, the other sales. And she ruled on this XRP is not a security in a very interesting way. She quoted other cases which say kind of the same thing. And so it's called what's called dicta because it's not an essential part of her order, but it is in there. And so what's been running around in my mind recently is I don't think you can appeal that, because you can't appeal something that's not officially ordered. How can an appellate court overturn her? Because she never even ruled on that officially. And so she's kind of put, I think, and I'm still kind of as I'm vacationing, I'm trying to kind of think about this while I'm driving and stuff, driving around with my kids. But I don't think that's appealable. I really don't. And so even if the SEC does appeal it, they might change, the appellate court could change her ruling as far as you have to know who you're buying and selling from in order for there to be a sell of a security. But I don't think that any appellate court can touch that part of the order which says XRP in and of itself is not a security, which is really what's important for the XRP holders.
Yeah, great. And I mean, like, even like, to circle back to what I was saying in the beginning of the interview, it's not like they're going to undermine what she writes. They're going to take in new facts, they're going to take in new circumstances, right? Or the stuff she didn't clearly address, right? She didn't clearly address the secondary markets, even if there was an appeal. But as you said, it's not like there's definitely going to be an appeal. It's just something that people are saying anyway. So regardless, I don't know. I feel really good about everything anyway. I'm optimistic that a lot of this has been clarified, and I think we're going to get more congressional input rather than being kicked down the road further. So I really appreciate you coming onto the show, Jeremy.
Not a problem. I love your show. Been a big fan of it for the last 2 years, and I give myself at least a week to just celebrate anything. So I haven't really been thinking about it too much. This is just celebration time. I'm really happy for everyone.
Yeah, I am too. Everyone's jumping with joy, and it's just great to see the dark cloud over us moving away.
Yeah. Well, I bought XRP a month into the lawsuit because I read it, and I read the lawsuit. I was like, this is not an easy case for the SEC to win. So I bought around, when it was back at 33 cents or whatever. So, I'm a happy camper as well, just from, owning XRP myself. So.
Yeah, I remember you saying that you bought in like as the case came about. So that really tells you a lot about how badly they set it up. I appreciate it.
Yeah, well.
Thanks, everyone. I hope you enjoyed the show. Please take a moment to like and subscribe. If you enjoy content like this, please consider joining my Patreon or my Ghost site, dmjr.ghost.io.